birthday of Abraham Lincoln and my best friend Carol Gartenberg growing up. Today we're just going to go ahead and open the hearing on House Bill 2593, and we'll have Natalie give us an overview. Thank you.
Thank you, Madam Chair. House Bill 2593 amends the Uniform Arbitration Act of 2000 to make certain agreements to arbitrate in contracts of insurance, and it also invalid. It would make those agreements to force arbitration in contracts of insurance invalid, and then it creates exceptions to that general rule. The bill amends KSA 5428. That's the statute in the Uniform Arbitration Act that provides for the validity of agreements to arbitrate. Current law there provides that an agreement contained in a record to submit to arbitration any existing or subsequent controversy arising between the parties is valid, enforceable, and irrevocable, except upon a ground that exists at law or in equity for revocation of a contract. This bill would create an exception to that general rule and provide that an agreement contained in a contract of insurance to submit to arbitration any existing or subsequent controversy arising between the parties shall not be valid, unless it is contained in a contract between insurance companies. And I can take your questions.
Okay, thank you. Committee, do you have any questions for Natalie? Please understand that she had a big weekend this weekend, so she was able to cheer on the Chiefs, not in person, but in the same town. So, okay, I hope you don't mind me saying that. No questions, anybody? Okay. She hurry up and sit down. Okay, thank you. Then we will go ahead with proponents. Joe Molina from the Kansas Bar Association.
Good afternoon. I was watching the game, so my voice is a little hoarse. I apologize. Joe Molina with the Kansas Bar Association. I appreciate the opportunity to have a hearing on House Bill 2593. This is our second attempt at doing this. I believe we've got a little bit of a larger audience this time. But in order to understand why we're here today, I think we need to go back and understand where we were pre-COVID in 2018. The reason we're here today is the Kansas Bar Association decided in our great wisdom that we wanted to go ahead and update the arbitration laws in the state of Kansas. So in 2018, we went ahead and introduced the Uniform Arbitration Act of 2000. That bill was based off recommendations from the Uniform Law Commission. It went ahead and it revised a bunch of statutes regarding the Arbitration Act. And before this, it had been 15, 20 years before Kansas had even talked about updating the Kansas arbitration laws. And so I don't want to say it was a fully overhaul, but it was significant. So we can say that. So in 2018, we went ahead. And some of the things that we wanted to cover was providing for provisional remedies, consolidating of proceedings in arbitration cases, disclosure of who the arbiters would have to be. We didn't have those types of rules back in 2018, so we need to update those. But what we didn't intend to do, what was an unintended consequence, was the removing of a provision in the Kansas arbitration laws that prohibited arbitration among certain contracts, and specifically in insurance. No one actually thought of that. We never thought we were going to do that. It wasn't our intent. It wasn't anybody's intent. When I went back and looked at people who testified for that bill, the only people that testified was a representative from the Kansas Bar Association and a representative from the Uniform Law Commission, none of which even discussed removing that provision. Right? So that's why we're here today. We would like to put that provision back. It was never our intent to do that. One of the reasons we want to go ahead and put that back is it was supported by case law. We have a Supreme Court decision. I believe I cited in my testimony, Tommy Friday versus Trinity University, Universal of Kansas, 262 Can 347 from 1997. So we have a law that the Supreme Court looked at on this provision. And now that that provision is taken away, that law no longer applies. And thus provisions containing arbitration can actually go into effect. I believe that has been the case. I believe they've been submitted towards the Department of Insurance, and they've been reviewing those since it's actually gone on. So the KB's position is since there was no real policy decision on why we should remove the provision in the first place, we would like to set the record back to pre-COVID days of having that back. And then if you guys want, you guys can have that discussion. But the KB's position is we would like to go back in time a little bit and maybe fix the unintended consequence and then move forward. I'm happy to stand for any questions.
Thank you. Committee, do we have questions? Yep. Representative Carmichael.
Thank you, Madam Chair. I recall the circumstances many years ago, and I didn't realize that we were doing this either, because believe me, you would have heard from me if your bill proposed this. But if we were to adopt this bill, which would vitiate, if you will, our mandatory arbitration and insurance contracts covered by the law,
Yes, sir.
would the parties, though, still be entitled, once a dispute arises, to voluntarily enter into arbitration? In other words, the insured and the insurance company both say, yeah, we'd rather go dispose of this with an arbitrator, or would they be required to resolve their differences in court?
No, they would be able to go ahead and negotiate that if they wanted to have arbitration within their insurance contract, or if they wanted to have it resolved in other ways, go to court and have someone else figure it out. They would still have that fundamental ability to do that. It'll just be negotiated. Whereas now it's not, because it's a contract of adhesion. So if it's in there and you're an insurer and insured, I should say, then it's just part of the insurance contract. And we're talking about everybody in this room has insurance of this type. And so it probably affect most of the people in this room.
My second question, Madam Chair, perhaps to clarify, I thought you said they could have it in the insurance contract. If they can have it in the insurance contract, that means before the dispute ever arises, the parties are bound to arbitration.
That is correct.
So are you saying if this bill passed, that we could still have these adhesion contracts where the insurer prints up the form and it requires arbitration?
I have a smarter guy here.
Okay, I know the smarter guy. He's also a brave airplane pilot. I'll defer my questions, Madam Chair.
Sorry.
Did you want to call up someone else to answer the question, or
Russ?
So
Yeah.
would you introduce yourself? Thank you.
I'm Russ Hazelwood. I'm a lawyer in Wichita, Kansas. And to answer your question, for 50 years, almost 50 years, from 1973 to 2018, the insurance policies could say, if you and we both agree, we can submit this claim, but it requires agreement on both sides. What the law changed is it allows the insurance company to force the policyholder to that dispute process against their will. And that would be, if this bill was passed, it would set it back to the way it was and say only if both sides agree. I think
That
that's somebody who's going to testify
question.
before
Thank
me.
you, Madam Chair.
I'm sorry, Representative Carl.
I said that answers my question. Thank you, Madam Chair.
Representative Heiberger has a question.
Thank you, Madam Chair. A question for Joe. You said that there was case law on the subject now. So under that case law, are these mandatory arbitration clauses enforceable?
Not under case law from the previous iteration. Before we actually went ahead and changed it under the Uniform Arbitration Act of 2000 in 2018. So before we actually had case law, and now that actually won't move forward because the law changed.
Thank you.
Yep.
Okay, committee, any other questions for Joe? Okay, thank you. All right, I'll go ahead and call up Tamara Anwar, citizen.
Hello. Good afternoon, Madam Chairwoman Humphreys and the House Judiciary Committee. 756 days. That's how long it took my family and I. We waited for a resolution for our insurance claim using the appraisal process. My name is Tamara Anwar. My husband and I own a small dairy farm in Northeast Kansas. There we live with our 2 children and my elderly mother. On December 15th, 2021, our home sustained severe structural damage due to a windstorm. I filed a claim the following day, optimistic that my insurance policy would protect my investment. What transpired over the next 2 years was financially, mentally, and emotionally draining. I did not agree with the insurance company's assessment. I was offered just under $8,000 for the damages. I hired my own adjuster, and his assessment of damage reached 6 figures. For months, we were in limbo, adjusters and engineers coming through our home, and no resolution could be reached. At this point, I understood my policy required me to enter into the appraisal process. I represented myself in Pottawatomie County District Court to have an umpire appointed. After the umpire had made his inspection, he deemed our home unsafe to live in. We had no other option but to remain on our farm. The umpire's award letter was submitted to the courts, and the insurance company still refused to pay. I hired Russ Hazelwood of Graybill and Hazelwood LLC to represent me as a policyholder. The insurance company then moved our case to federal court. I cannot begin to express the stress that this imposed on my family and my business. The appraisal process cost me in excess of $6,000 that was never reimbursed. The appraisal process is expensive, long, drawn out, and offers an unfair advantage to the insurance companies. HB 2593 will restore the law that protects Kansas policyholders from an experience like mine. Thank you.
Sorry. Committee, any questions? I wasn't on the mic. Yes? Did you have your hand? What community do you live in? Just out of when you said Northeast, I was
just north of Wheaton, Kansas.
Okay. All right. Thank you. Okay. Committee, no questions for Ms. Anwar? Okay. Thank you for sharing with us. We appreciate it.
Thank you for your
Okay. Callie Denton from Kansas Trial Lawyers. Welcome to committee, Callie.
Thank you, Madam Chair and committee. I am mostly written only. My testimony contains everything from the KTLA, and I think it would be better if Mr. Hazelwood were to come up and testify since he deals with these cases.
Okay, that's fine. So you submitted written.
I did.
Have you written?
Yes. Thank you so much.
Okay. Thank you. Mm-hmm. And Russ Hazel were from Graybill and Hazelwood LLC.
Thank you again.
Yep.
Chairwoman Humphreys and the committee, I appreciate the opportunity to testify. My law firm is one of the very few law firms in the state of Kansas that protects or that represents insurance policyholders. Most of our clients are businesses. Most of our clients are building owners, developers, retail companies with inventories, rental buildings and things like that. And all of them are consumers of insurance. For almost 50 years, certainly since I've been practicing law the entire time, there has been a rule in Kansas that you cannot have an insurance policy that forces a policyholder into what's called an appraisal process, which is a light version of arbitration against their will. Consequently, I never let my clients enter into it, and frankly, don't get around it that much because it's essentially you pick a guy, they pick a guy, they pick someone in the middle, and the three of them tell you what you're going to get, and there's no hearing, there's no evidence. You don't know what you're going to get. You just get a number. It was not really until Ms. Anwar's case that I got a real good look at this system because, again, I wouldn't let my clients enter into this. But Ms. Anwar came to me and she'd already gone through that process and she had won it from my perspective. She had an award of $182,000. But what I learned looking at that is the way that the insurance companies write these contracts, if they win, she would have been stuck. If they'd have said $7,000, she'd have been stuck. But since the insurance company won, they reserve additional defenses. So they can say, well, you came to that number, but that was for things that weren't covered. That was for things that there are other policy defenses we can raise. So even though she had effectively won before I met her, we still had to go to court. When we went back to the Pottawatomie District Court, they then removed us to federal court. And then we had to litigate for another year. So, and by that time, she had to pay her appraiser $6,000 before she met me to come up to that award that the company was saying is useless. So I implore you for my business. I mean, I think I saw in some of the testimony that this change, this unintentional change is somehow pro-business. My clients purchase insurance. If you own property in the state of Kansas and you insure it, this is not good for you. It is not good for you as a business, and if it's not good for you as an individual, you can, if Boeing has some kind of an insurance claim and they're trying to figure out what's the value of some discrete piece of of equipment, it may make sense to arbitrate that. So to Representative Carmichael's question, Boeing can say, sure, we got the rest of the claim resolved. We'll arbitrate what is the value of this piece of property. And that may well make sense, and both sides agree. But in this case, what the current state of the law, because of this accident, is that the insurance companies can force individuals and unsophisticated businesses into a process that is loaded on one side. If the insurance company wins, that's the result. If the policyholder wins, then we start over at scratch, and they'll come to me just like Ms. Anwar did. I ask you to put the law back like it was for 50 years. It worked fine for 50 years. Please fix the mistake. And if we're going to have a sea change in the law like this, let's have a policy debate.
Thank you. Committee, do we have any questions? Representative Schreiber.
Thank you, Madam Chair. Thank you, Russ. This isn't an area that I know.
Sure.
I know nothing about, but would arbitration be allowed if both parties agreed, or
Absolutely.
This is just about forcing them within a contract to
neither side can force the other side into an arbitration,
but they could do it.
But they can do it by agreement. And the policy forms. So in most insurance companies, policies are written on forms that the industry promulgates, and it will say, up to this point, if you and we agree, the matter may be submitted to appraisal as follows. And since this change, they will say, if either of us demands this procedure, then that's what will happen. And I can assure you that it won't be the policyholder that's demanding this procedure, it'll be the insurance company. And the fact that you don't understand it makes you within 99% of consumers of insurance in the state of Kansas.
Thank you. Thank you, Madam Chair.
Welcome. Representative Carmichael.
Thank you, Madam Chair. Mr. Hazelwood, please make sure and give my regards to your partner, Jake Grable, because when I used to represent insurance companies, he used to beat me like a drum and tell him I haven't forgotten those whoopings. My serious question, though, is there is some additional language at line 14 of the bill on page 1, and I'll just read it to you if the chair permits. It says, except for those contracts between insurance companies, including reinsurance contracts. And then it goes on to say the other types are not valid or enforceable. I think I know what that means, but could you explain it to us?
Sure. That means if a large insurance company has a way of hedging its risk by doing a contract with an even larger insurance company, if they choose to enter into contracts that have arbitration, those will not be adhesion contracts. Those will be heavily negotiated contracts. So it's very different than an insurance policy. So we're not prohibiting them from tying themselves up in those kind of arrangements. And the real difference, everyone's bought insurance. It's not like you even get the policy when you buy the coverage. You pay your premium, and then a month or so later, you get in the mail the contract. And because this is that kind of contract is why it requires a special kind of protection from the legislature for this class of people and businesses. And please don't forget, if an individual like Ms. Anwar has her case and she comes to me and her house has been unlivable, she will not die. She'll be uncomfortable. She'll move in with her relatives or whatever. Most of my clients are businesses. So if you have a business that has a commercial building that rents out space, or if you have an inventory of property that you have to sell and it takes you 762 days to get your insurance paid back, as a business, you will die. It's a death penalty. So please don't overlook the fact that this change that accidentally happened is very anti-business. Thank you.
Thank you, sir. Thank you, Madam Chair.
Yeah, Representative Lewis.
Thank you, Madam Chair. I just don't understand in the case that you litigated how, after the appraisal, the insurance carrier was able to move it back into a court, and in this case, federal court. I understand how they removed it, but how did they have? What was the grounds on which they went and then started litigating in court?
So there are legal nuances in appraisal, which is an insurance company construct of the arbitration process that allows basically the appraisers come out and they determine the amount of the damage. And so what happens is when you get your award back, they'll say, well, okay, there was $182,000 worth of damage, but this wasn't caused by the wind, and this wasn't caused by hail. And oh, by the way, there are these other policy provisions that we can raise and assert that the appraisers do not get to consider. So therefore, you get drawn into court anyway. So even in the court order that Ms. Anwar got, where the court had to pick an umpire when they wouldn't agree which umpire it would be, so she had to file her own pro se case. Even in that, the order said there were policy defenses reserved to the insurer.
And why weren't those arbitrated as well, or
Because
subject to the appraisal process?
Because that's not how the insurance industry writes its arbitration provisions. Since arbitration is a matter of contract, they can create the policy themselves in the language that they choose in their adhesion contract. And the way these policies are written, they are not all encompassing.
Thank you.
I do have one quick question for you. And that would be just so I understand. We had it before. We did the Uniform Arbitration Act, and the Uniform Arbitration Act doesn't have this piece in it across the country. I mean, we did pass the Uniform Arbitration Act, or was it not compliant with the Uniform Commission, or what happened?
So different states handle insurance in different ways. That's partly because under the McCarran-Ferguson Act, insurance is one of those very few things that is expressly reserved to the states. So the original version, and I just went and got the legislative history today, the original version of the Uniform Arbitration Act was passed in 1973. But at that time, Kansas added this language. So this House Judiciary Committee in 73 never considered the Uniform Arbitration Act without this language. It was a Kansas home rule. Other states have similar prohibitions, but they're in different places in their law. So when the Bar Association said, hey, let's modernize the law, let's update the Uniform Act, they overlooked the fact that Kansas had added that language to our version of the Uniform Act.
Okay, thank you. That's helpful. Okay, any other questions? Representative Mon.
It's nice to see you again. So the language was accidentally removed has been brought up several times. Why are we assuming it was accidentally? Ordinarily, when the legislature acts, we presume that they acted on purpose. So why do we think that this is?
Well, we've had testimony from the proponent of the change that this was not a reason that they contemplated at the time, that there was no testimony or anything like that was given that it would make good sense for business or for policyholders or for the state in general to remove this prohibition from the law. Frankly, no one who was doing it recognized in real time that that was happening. And frankly, I didn't know it had happened until Ms. Anwar's case when the insurance company raised it, because I said, why did you have to arbitrate in the first place? But in most instances where you have a change to the law, there will be a bill and there will be a black line through it that says, okay, and someone like Representative Carmichael says he would say, wait a minute, this might not be a good idea. In this case, because they were just plucking one and putting in another, and everybody was saying nothing to see here, we're just modernizing the law. There was never a policy debate on this issue.
Thank you.
Okay, thank you. Okay, committee, we will now call up the opponents. Eric Stafford from the Kansas Chamber. Welcome.
Thank you, Madam Chair and committee members. Good afternoon. I'm Eric Stafford with the Kansas Chamber, Colts fan in Chiefs territory, so congratulations. We hope to beat you next year, maybe. We got a long way to go. Representative Carmichael, are you saying you're a Colts fan as well? Good afternoon. Appreciate the opportunity to testify today, and I will echo Mr. Molina's comments that there are going to be people smarter than me who testify after me about the intricacies of this. But this issue was flagged for us out of concern that we would prohibit businesses from being able to enter into arbitration agreements, which are oftentimes viewed as more positive alternative to litigation, just to work out differences and disputes while saving expenses of having to litigate disagreements or disputes. So that is really the main reason why we are here today. I know that we have heard several times, I think, to Representative Maughan's question about the intent back in 2018, and I think there's some disagreement on whether it was intended or not. But today, this issue that did get brought up from our membership to us is definitely one of concern, that it's going to hamstring their ability to enter into these types of agreements in their contracts. So you can read our written comments, and I'll let some of the other experts go into more legal detail, but I am happy to answer any questions now or later, whatever arises.
I think we'll go ahead and do them now if you're okay with that.
Sure.
Committee, and do we have questions for Mr. Shefford? Yes, Representative Carmichael.
Thank you, Madam Chair. I think I hear you say the Chamber's concern is that this amendment might somehow prevent businesses from entering into arbitration agreements.
Yeah, specific to insurance companies. Yeah, that was their interpretation.
So when we're talking about what's been described as adhesion contracts, one where the insurance company sends out all the details of the insurance contract later on, and that agreement prohibits, or excuse me, that agreement requires arbitration or appraisal. Is that okay with the Chamber for the insurance company to send out a requirement that unilaterally requires parties to give up their right to go to court? Or is what the Chamber wants to just make sure that two businesses, if they want to arbitrate a dispute, that they can still go ahead and do that?
Well, I think that this is preventing that action altogether. Is the interpretation that we were receiving, is that it's banning the types of contracts from the insurance company to the business that they're insuring. So the carrier's insuring the business, that they would not be able to have arbitration agreements based on Section 2.
Do you understand my second question? Do you understand, though, that if both businesses are in agreement, or for that matter, a business called an insurance company and an insured called a person are in agreement, that they can still go ahead and arbitrate their disputes just like current law? Do you understand that?
An agreement contained in a contract of insurance to submit, and I'm not an attorney, but I did not sleep well last night. So an agreement contained in a contract of insurance to submit to arbitration any existing or subsequent controversy, except for those contracts between insurance companies, shall not be valid.
Right.
I don't think this language is differentiating between negotiated by both parties or mandated.
Madam Chair,
maybe I'm wrong.
If you would indulge me for just a moment, I think what it says is, if the agreement to arbitrate is in the contract of insurance, it's not enforceable. But if the insurance company and the insured agree after, separate from the contract of insurance, agree to arbitrate a dispute in lieu of going to court, that they can still do that. That's the distinction. But if you don't follow, that's okay. We've got experts back here.
Sure, I'll defer, because I don't know. Based off what we heard from our members, I don't know if they interpret this language to read that way. Yeah. Thank you, Representative.
Any other questions, committee? Okay, thank you. Appreciate you being here. Alex Young from American Council of Life Insurers. Welcome to our committee today.
Appreciate it. Thank you, Chairman Humphreys and members of the House Judiciary Committee for having me today to testify in opposition to H 2593. Again, my name is Alex Young. I'm with the American Council of Life Insurers. I'm a regional director there. The ACLI is a trade organization that represents 275 member companies across the country. I submitted written comments to the committee late last week, which you should have. Again, I won't go through that word for word. You can view it at your leisure. But I wanted to point out a couple of issues that we had found with the bill that we wanted to highlight as to our opposition. Firstly, arbitration offers several benefits to consumers, primarily providing a faster and more cost-effective resolution to disputes compared to traditional litigation. Secondly, I would highlight that another advantage of arbitration includes that consumers have the opportunity to select arbitrators with expertise in the relevant field, potentially into more informed decisions. In short, ACLI is opposed to the bill because it's not only bad for business, but we believe bad for consumers, which is more important. I want to thank you again for letting me come testify today, and I look forward to future discussion on the bill.
Okay, thank you. Committee, do you have questions? Representative Lewis.
Thank you. You heard the testimony about this lady's problem and the runaround she got. How do you react to that?
Well, that sounded like a dispute over it was property involved. So again, my the trade association that I represent is more life insurance and annuities related. So I can't really speak to this particular instance, but I appreciate the question.
So are you suggesting that we carve out exceptions depending upon the industry we're talking about?
No, I can't speak to the process or what the holdup was with that filing. But again, I can follow up with some of the folks that I have and see if there's similar circumstances, and I can get back to you. Yeah.
Thank you. That's all.
Okay. I mean, if you would like some examples, we could get that to the committee if you have that.
Yeah, absolutely.
Okay. Yep. Thank you. Okay, Representative Titus.
Thank you, Madam Chair. I'd be just curious, could you give some examples of how this would be beneficial to customers?
Arbitration specifically?
Being forced into arbitration, yeah.
Yeah, I mean, again, I highlight several examples in the written testimony. Again, I mean, the expertise of the relevant field for consumers allow them to make a more informed decision. Again, I can ask my policy folks back at ACLI if there's more examples that they can give, but that's kind of in the written testimony I have. I explain a little bit more thoroughly. Yeah.
Okay, committee, any other questions? Representative Mon.
So if it's beneficial to the insured, without this mandatory provision, the insured could always go to the insurance company and say, hey, let's arbitrate. And if the insurance company agrees, then that would be fine. So if we take out the mandatory provision, there's always the possibility of arbitration between both parties. Is that right? Is that the way I read this?
I don't think our member companies were concerned with the language that was contained in the bill. I would have to specifically inquire with them.
Right. Thank you, sir.
Sorry.
Okay, committee, any other questions? Okay, thank you. We appreciate you coming to the committee today. Now we have Robert Passmore from American Property Casualty Insurance Association.
I'm here remotely, Madam Chair.
Okay, thank you so much. Welcome to committee.
Thank you. Good afternoon, everybody. I'm Bob Passmore. I'm Department Vice President from the American Property Casualty Insurance Association, which is better known and easier said as APCIA. Let me join the chorus of people congratulating the Chiefs on their victory. It was a thrilling game last night. It was great to watch. But if you're not familiar with APCIA, we're the primary national trade association for the home, auto, and business insurers. Together, our members write about a little bit over 66% of the property casualty insurance sold in Kansas. That represents a little bit over $5 billion in direct written premium. I'd like to thank the committee for the opportunity to talk to you today about our concerns with House Bill 2593, which is written, or our interpretation is, would prohibit the use of arbitration clauses in insurance contracts that have been used for decades around the country to quickly resolve disputes and reduce the cost of litigation for businesses and consumers alike. Mandatory arbitration clauses are relatively rare in property casualty insurance policies. Where it is used, it's used the same reason it is in any other kind of contract, because it's an effective, efficient, and speedy means of resolving disputes without destroying business and customer relationships. Not only is litigation costly and time-consuming, but its strong adversarial nature, the process tends to damage the relationships between the litigants because it's a little less formal and a little more user-friendly. It tends to minimize hostility and emphasize post-dispute relationships. There's a lot of studies that are referenced in our written testimony that find that plaintiffs or claimants generally get the same or better outcomes in arbitration than litigation, which is why some states specifically authorize binding arbitration of disputes over the amount of, say, a policyholder's uninsured motorist claim for bodily injury or property damage. Which brings me to an important distinction. A lot of the concern that we hear generally about mandatory arbitration clauses arises out of other kinds of consumer contracts, such as those used for cell phones, internet, and streaming services, which aren't subject to the kind of robust regulation that insurance policy language and pricing is. Like most other states, Kansas requires insurers to file their policy language with the regulator, who then has the power to reject policy language that would prescribe unfair arbitration terms or procedures. ISO, the organization that develops policy language that many insurance companies use, has filed and in most states has received approval of personal auto and homeowners policy endorsements that create a binding arbitration process to resolve appraisal disputes, as well as policy endorsements that provide mandatory arbitration of coverage disputes for commercial policies. The courts add another layer of consumer protection and have not hesitated to strike down provisions that subject consumers to unfair procedures or processes. We've already heard mention of something that's similar to arbitration, but it's not really considered arbitration, and that's appraisal. There's two places where you do see commonly arbitration or this kind of language in a P&C policy, and that would be either arbitration of uninsured motorist claims, which I talked about before, which is required in some states, and the one that we heard about today, the appraisal process for property damage claims. And as was said before, these provisions typically require one or both parties to agree to submit the dispute for resolution and are limited to the amount of the loss, not any coverage issues. Issues of coverage or questions of whether or not the insurer acted in good faith are reserved for the courts, and policyholders can and do pursue those remedies in addition to the arbitration or appraisal process. From the language of the bill, it's pretty broad, and it seems like it wasn't clear whether it would apply to the appraisal processes or not, but given some of the testimony today, it seems pretty clear that it is. We think that the appraisal process has been used to benefit consumers all around the country for decades. And I guess it's even though it may have been unintentional that prohibition was removed, it gives us an opportunity to talk about this issue before any decision is made about going forward about eliminating with a broad brush all these kinds of different procedures that could benefit consumers. The bill does preserve the ability to include arbitration language in contracts between insurers, including reinsurance contracts, which are really kind of insurance for insurers. That allows insurers to take on more risk. In some cases some places that are subject to a lot of different natural catastrophe perils. Reinsurance is what allows companies to continue to offer writing insurance there. So that's an important distinction that was made in the bill. So that's a good thing. Other kinds of agreements that happen between insurance companies there is an intercompany arbitration process. So if two insurance companies disagree about a subrogation claim between the two, there's an arbitration process for that the two companies would be bound by. So this would preserve those as well. Again, a good thing. But it also doesn't recognize that mandatory arbitration clauses are more common in commercial insurance. And I think that's what one of the previous witnesses was talking about. Businesses often have their own risk management experts, or utilize the expertise of insurance agents and brokers, or even have legal representation when they purchase insurance, providing yet another layer of protection for commercial policyholders. In some cases, they actually negotiate the language that's in that commercial policy. And this, according to our interpretation, would completely eliminate that as well. They would not be able to even negotiate. This is a very broad brush. So in closing, we don't believe that this bill is necessary because the insurance regulator already has the authority to act should an insurer's policy language on arbitration fail to meet the standard of fairness. And this proposal would be a blanket elimination of a process that has served policyholders well for decades around the country. So on behalf of our members and their customers, we urge the committee to vote no on House Bill 2593. With that, I'll stop and happy to answer any questions.
Okay, thank you so much. Committee, do we have questions? Representative Lewis.
Thank you, sir, Madam Chair. Thank you. You heard the testimony. You've heard all the testimony that we've received today.
Yes.
Right. Yeah. So, do you think that the situation that brought this to our attention is that uncommon or common, where an insurer, as I understand it, writes a policy which allows, as you said, for arbitration or appraisal for the loss amount, but then reserves the right to litigate over coverage? Is that common in insurance companies? And the problem that this lady raises, is that uncommon in your view?
Yeah, coverage issues are usually reserved for the courts, and the reason for that is pretty simple: is that insurance policy language has been interpreted over the years and precedent set, and you heard talk about case law. All those things would still be in effect. So if we're going to decide whether or not something, what's covered under the policy contract or what's not, the proper venue for that is indeed in the courts. What the appraisal process is designed to do is, when there are no coverage issues, is determine what the amount of the loss is. And the vast majority of claims, that's something that gets worked out between the insurer and their policyholder and their contractor or their public adjuster, or whoever it might be, and without even having to enter into this kind of process. But when there is an honest disagreement between the parties about how much the loss is, then that's what this process is for: is to not litigate something like that, and not take something like that into the courts, but to try to address the scope of the loss or the amount of the damages in the appraisal process. So yeah, that is common that those questions of law about the policy and what it covers, that's the court's domain. The questions of damages, that's when the appraisal process is intended.
Thank you, Madam Chair. One more question. I think you suggested that in most instances, coverage issues are resolved before the appraisal. Do you have any idea as to why that didn't seem to happen here?
You know what? I'm not privy to the details of this case. It wouldn't be right for me to comment on that.
Go ahead.
What causes that then you to say that normally coverage issues are resolved before appraisals? Is that your experience, or is there something in the law that requires that?
I guess my experience is somebody who worked in claims for a long time is usually coverage. You determine whether or not the loss is covered first.
Thank you.
Representative Smith.
Thank you, Madam Chair. I'm having a hard time getting past the idea. I keep hearing litigation is costly. It takes a lot of time. It's not as good as arbitration. But then I look at the list of conferees, and all but one of 7. So 6 conferees are insurance companies. Sounds like arbitration is a pretty handy thing to have. I'm curious, in her testimony, that Ms. Anwar, who testified earlier, in her situation, you had a check for $8,000 handed to her when she knew what she was looking at was way in excess of $8,000. And I'm going to propose that the person handing the check also knew that it was in excess of $8,000. We get to a 6-figure sum from an adjuster who has no dog in the fight. And then what we're going to do is go to arbitration and find a number in the middle, because that will save about half what the insurance company would have had to pay in the beginning. So I'm trying to get past this idea that litigation has somehow become this unfair advantage. Why is it not fair? Here's the question I was leading up to. Why is it not fair to allow each party to decide whether arbitration is the route to go? Simple.
I guess in that particular, well, I guess that my answer to that would be that it's a process that has, in most policy language, at least on the personal line side, does usually say it gives the option to both parties. Different companies can't have different policy language. In fact, there's some insurance companies out there that don't have appraisal clauses. and that's up to them to make that choice. I'll tell you that there also have been some issues for insurers with the appraisal process, not in Kansas, but some other states. Sometimes you get some parties involved that have used it more tactically than anything else. You get auto body shops that have availed themselves of this procedure. So, it's by no means is the appraisal process risk-free for an insurer either. But for the most part, it's a way to, litigation is always going to take a little bit more time. It's going to be more costly for both parties. The appraisal process is a way to resolve the vast majority of disputes quickly and fairly, with a minimum of time and expense to both parties.
Representative Schreiber.
Thank you, Madam Chair. Kind of a tag along to that, to Representative Smith's question is, I think you'd mentioned that, if it did go to arbitration and there was a dispute, then the state insurance department could weigh in on the fairness of the settlement or whatever it might be called. But doesn't that just continue the delay on, providing some relief to the insured?
No, Representative. What I said was that the policy language is, insurers have to file their policy language with the Department of Insurance, and if they're the regulator, the Department of Insurance in this case, if the policy language is, doesn't meet their standards of fairness, or they feel that that is not appropriate, they have the ability to reject that policy language.
Okay,
and
I misunderstood what
yeah.
you'd said earlier. I thought it was in relation to a claim. You're talking
No.
about when you submitted initially to the insurance department.
Right. Every
Okay.
department, I know the Kansas Department of Insurance also has a complaint procedure that consumers avail themselves of. And if they feel they've been mistreated, they file a complaint with the Department of Insurance, who can and will sometimes get involved in some of those situations. But on policy language issues, their authority comes in before they, when the insurer makes the filing and files the language they want to use for their policies.
Okay, thank you. Thank you for the clarification. Thank you, Madam Chair.
Representative Titus.
Thank you, Madam Chair. Mr. Passmore, if fair is fair for the consumer, would you support a version of this bill that prohibited insurance companies from pursuing any additional defenses in court and binding them to the arbitration process?
Well, I think if it is truly a binding arbitration clause in the contract, that's what the language of the policy would say. Like I said, in most property casualty insurance policies, that's there's two kinds that are most common: uninsured motorist and the appraisal, and a related issue, the appraisal clause. Both of those are the mutual option in standard policy language. But there are variations from carrier to carrier, and that is a question that consumers can ask when they see that policy line, or they can ask to see that policy language up front when they're shopping for insurance. What does your policy say about appraisal, or what does your policy say about arbitration, if they're concerned about those things?
And it would be your opinion the average consumer is sophisticated enough to make that determination on the front end?
Oh, that probably not. I wouldn't say sophisticated enough. I think they can understand it if a lot of people don't. I guess a lot of people don't necessarily read their policies, and they should. A lot of us should be more familiar with what's in that policy, and the time to do that is before the loss happens, to make sure you're familiar with what's covered and what is not.
I don't disagree with that. Thank you.
Representative Heiberger, you have a question?
Yeah, thank you, Madam Chair. Mr. Passmore, you mentioned that a lot of the contracts of the kind we're talking about have arbitration provisions where either party can request arbitration. Is that
Yes.
that either party can request it or either party can require it?
They would run the gamut. There'd be usually the contract. I think if there's a contract language that requires it, that could be mutual. That could be on the insurer. It all depends on how the insurer decided to write the policy language. What's most common is it's a mutual option.
Mutual option being either party can require it.
Either party can request it, and either party can reject it.
Okay, thank you.
Mm-hmm.
Okay, committee, are there any other questions? Representative Carmichael.
Thank you, Madam Chair. Mr. Passmore, looking at your letterhead here, I see that you office in Washington, D.C. and Chicago, Illinois.
Yes.
That, just so we all understand, where are you now?
I'm in Chicago.
Okay. Are you licensed to practice law in Kansas? Have you litigated cases?
I'm not a lawyer.
Well, Madam Chair, the reason I ask, and I'll put it into a question to this gentleman, this layperson from Chicago, I've served on the Rules and Regulations Committee for 5, 6, 7 years now, and I've practiced in this state for years, and I'm not aware of any legal authority that permits the insurance company to vitiate provisions of an insurance contract on the basis of fairness when the law specifically allows the clause. Mr. Passmore, can you direct me to the authority here in Kansas that would allow our insurance commissioner to take that drastic action? Because I was unaware of it.
They have authority to review and take action on any any rates that they deem either excessive or unfairly discriminatory, and the same kind of thing would apply to policy language as well.
Can you direct me to any citation by way of statute or law that supports your assertion?
Off the top of my head, I cannot, but that's something I can get back to you.
Please do, if the chair would like to hear that from that authority, because I don't think it exists, ma'am.
Yeah, that would be great. It's kind of the practice if one of the committee members asks for information. If you could provide it to us, that would be great. Thank you. Okay, committee members, do we have any other questions for Mr. Passmore? I think he got it. Representative Mon.
So my understanding is, at least in the consumer realm, the federal government and the Consumer Financial Protection Bureau are kind of moving away from the idea of mandatory arbitration clauses. And I'm wondering, shouldn't we just get ahead of that and do away with this now, rather than wait for the federal government to tell us what to do?
Well, I think one of the other witnesses pointed out is that the insurance is the purview of the states. The McCarran-Ferguson Act, puts that in federal law. So I don't believe that that would be within the federal government's authority to do. But you're right that there have been discussions about those kinds of things at the federal level and even state level, and that's what I mentioned in my testimony, that most of that revolves around consumer contracts like cell phones and streaming services and those kind of things, where on page there's information about binding arbitration there. But insurance policies have had this kind of language for a long time, and it's been used in a lot of places around the country, and been a good thing for both consumers and for insurers.
Thank you, Madam Chair. So the way the feds would get involved would be under UDAP, Unfair Deceptive Acts and Practices regulations. And I think that the federal government's move away from mandatory arbitration doesn't just include consumer goods, but also financial regulations and banking, etc. And I'm having a difficult time saying how the insurance company would be different than that.
Well, our position would be the same: is that we would oppose that kind of action. To I guess McCarran-Ferguson would be part of the issue, but also that and again, these kind of clauses have been used in insurance contracts for a long time and provided a good alternative way to resolve disputes that have benefited consumers and insurers alike.
Okay, thank you, Mr. Passmore. We appreciate you being here. We're going to move on to our next opponent. So thank you. Next committee, we will have Paige Blevins-Jones from Security Benefit. Welcome to committee.
Madam Chair and members of the committee, thank you for the opportunity to be here today. My name is Paige Blevins-Jones, and I'm in-house counsel at Security Benefit Life Insurance Company. And I'm here to testify today against House Bill number 2593. Put succinctly, and as previously stated, this bill is anti-business. If approved, it would make arbitration clauses in insurance contracts unenforceable, forcing all disputes to be litigated in court. We believe that arbitration has many advantages, including the fact that disputes get resolved more quickly and at a lower cost than litigation. Legislation that drives up the cost of doing business is ultimately borne by consumers. The bill also unfairly singles out the insurance industry. Arbitration in any other industry or segment of the economy is not made unenforceable by this bill. We can think of no good or valid reason for singling out the insurance industry. In sum, Security Benefit opposes this bill because it is bad for business and unfairly singles out insurance as opposed to any other industries. Thank you for the opportunity to be here today, and I'd be happy to answer any questions this time.
Okay, thank you so much. Committee, do you have questions? Representative Titus?
Thank you, Madam Chair. So since this was the law up until 2018, we've had about 5 years experience. How much have you been able to lower your costs to customers because of this change in law?
Security Benefit actually doesn't have arbitration clauses in their contracts for insurance, but that doesn't mean that we couldn't utilize that in the future. So I can't give you a specific number, obviously, because we don't have arbitration clauses.
Representative Lewis?
Thank you, Madam Chair. I'm taking from testimony of other conferees that the way they're reading the bill is that even though an insurance agreement couldn't require arbitration on its face, if at the time a dispute arises, the parties agree to arbitrate, that can be done. Is that your understanding of the bill?
Thank you for the question. That was not my understanding of the bill as written. It doesn't make it clear that we could then enter into a separate agreement for arbitration.
Would it make you more comfortable with the bill if we actually made that explicit?
Would it make me more comfortable?
Or less uncomfortable?
Maybe less uncomfortable is the word. I think that would be a benefit to the bill, but again, doesn't resolve all of the issues that Security Benefit has with the bill, including the singling out of insurance industry. So no, I don't think that would make me fully comfortable with the bill.
Thank you.
Representative Curtis?
Thank you, Madam Chair. So, Paige, my question is, why doesn't Security Benefit have arbitration clauses? Why don't you include those?
It's a business risk decision, right? So whether or not we have arbitration clauses in the policy really depends on what risk the business is willing to take. I wasn't privy to those discussions on why we don't have them. We just don't have them at this time. And I gather from that it's because as a business, we've just decided not to.
So a follow-up question to that, what problem do you see in requiring both parties to agree to an arbitration?
I don't, I guess, see a problem in having both parties agree to arbitration. It's just in these specific contracts and also in our specific business, it would not be something that we would want to do.
And so I think the intent of the bill is to require that both parties would have to agree to an arbitration versus insurance company being, forcing one party to. So you don't see a problem with that, with both parties having to agree?
I don't see a problem, obviously, in any contract with both parties agreeing. I would argue, though, that at least in our specific type of insurance, life insurance and annuities, that unlike a property and casualty type of insurance, usually individuals are shopping around for their specific contract. And so in this case, for our specific type of contract, they are shopping, right? So they do have a choice when they're looking at a specific contract that they're buying.
Thank you. Okay, I do have a question. I'm a little confused about something. I hope I don't have to go back to the beginning, but so we passed the Uniform Arbitration Act of 2000 and we passed it in 2018 or 19, I think. And so you're saying that this bill singles out the insurance industry, but that's because when we passed the Uniform Arbitration Act, it included every other industry, but not the insurance industry, because we had that little piece in there before 2018, and now we're just trying to put that piece back. So I'm not understanding how this bill singles out insurance, because we're just putting you back with every other industry, is my understanding. I could be missing something, but all this testimony, that's what I'm getting out of it.
So it feels a bit like a puzzle, and that's not my understanding of the bill as it's written in paragraph 2. Only it appears to me, and I could be wrong as well, that only the insurance industry is called out as having these provisions within contracts being unenforceable. I don't see any industry that would have that kind of pointed unenforceability, but I could be wrong as well.
So I'm wondering if another conferee has an answer to my question on that. Nobody wants to talk about one. Okay, we'll just maybe look into it a little bit more then. Okay, yes, go ahead, Mr. Hazelwood.
I don't know that we have a significant disagreement on this point. In 1973, I have the committee meeting minutes here, and one of the conferees, or the people who testified, I'm not sure what the language, but one of them was Mark Bennett of the American Insurance Association, who asked that language be deleted. And in 1973, this committee said no and left that language in. So for 50 years, approximately, we've had that language in, and for only the last 5, we've not. And so that's the difference. But I mean, yes, you are treating the insurance industry somewhat differently than other industries by having a specific provision that applies to insurance. And that's because of the unique position insurance plays in the way insurance contracts are bought and sold.
The Uniform Arbitration Act didn't include just insurance. It was other industries also.
Correct. The Uniform Act applied generally.
Yes, that's.
And then other states that have these prohibitions put those prohibitions in other places in their law. Kansas chose to plant it in the middle of by modifying the first part of the Uniform Act. And so that's why it was overlooked.
Okay, thank you. I appreciate that. Okay, do we have any other questions for Ms. Blevins-Jones? Representative Carmichael.
Thank you, Madam Chair. Ms. Blevins-Jones, I want to follow up with you on whether or not this bill would prohibit parties after the contract's been entered into, but when the dispute arises, from both parties agreeing to arbitration, appraisal, however we want to handle it. Now, do you still have concerns that this bill would prohibit the parties from entering into such an agreement long after the contract, but instead when the dispute arises, say, we'd really rather arbitrate this than go to court?
I again don't think that it's made clear in the bill. And additionally, to be frank, I don't see that happening. I don't see the two parties coming together to agree to arbitration.
Do you have the bill at hand?
I do not.
May I provide her with my copy? You'll see the italicized language there, which is the operative language. I don't have my copy now.
On line 12 through 16.
Yeah, and the very first words are, I don't have my copy. Could you share them with me? That top line?
I have it memorized. An agreement contained in a contract of insurance.
That's what I needed. Thank you. So you understand the agreements we're talking about are the agreements that are in the contract of insurance, not a subsequent separate agreement to arbitrate. That's a different contract. Do you understand?
I do.
Okay. Does that help relieve your concern?
No.
I didn't think it would. Thank you, Madam Chair.
Thank you. Okay, Representative Mon.
Thank you, Madam Chair. Ma'am, many of the opponents have indicated that this bill would be bad for business. How do you answer the question of when the insured is a business? Wouldn't this actually, making this change actually be good for the insured business, which basically pits probably small companies against the insurance companies?
My response is that the bill doesn't make a distinction between an individual and a business, right? And arbitration might be appropriate for a business who is an insured of a company. Again, I'm not a property and casualty, or I don't represent a property and casualty insurer, so I can't fully speak to that, but I can see how arbitration would be beneficial for a business who is an insured.
So I'd like to throw that out to the rest of the conferees. Perhaps Mr. Stafford or somebody else who can help me kind of, this doesn't seem to me to be an inherently bad for business bill. It may be uncomfortable for insurance businesses, but for businesses in general. If anyone wants to answer that, you don't have to, but.
And I'm happy to step aside, but I would also say that, again, litigation is just incredibly expensive. I mean, even filing and answering a complaint is incredibly expensive. And so arbitration clauses allow for a less expensive route to go than litigation.
And wouldn't that encourage a business insured to ask for arbitration? That seems to be what the insurance industry wants, is arbitration. And because of the expense of litigation, having the choice rather than being pushed into arbitration would probably mean that the insured would actually ask for arbitration. Doesn't that make some sense?
Yes.
Okay, I think we will leave it at that. I think we'll go ahead and just we'll look at our written opponents now, but thank you for coming to committee.
Thank you.
Appreciate that. Okay, committee, we have Roland Spies from State Farm Insurance, Marley Carpenter from Kansas Association of Property and Casualty Insurance Companies, and Rosalind from NAMIC Regional Vice President of the Midwest. Yes, Representative Bourgeon is going to ask a question. Thank you.
I am going to ask a
Okay,
question.
good.
Thank you, Madam Chair.
Yes.
I certainly appreciate all the opponents and proponents here today, and it's been good to listen to. But I wonder, is it appropriate to ask our insurance commissioner to look at this? I'm kind of surprised that they're not here to weigh in on the issue. Or maybe they have.
Representative Schreiber.
Thank you. Yes, I've heard that the insurance department has looked at it and would leave it to the legislature as a policy decision.
That's helpful.
Okay, committee, just a second. I think maybe there was someone on the list that I did not know about. Do we have Blue Cross and Blue Shield here? Okay, if you would introduce yourself.
Happy to. Thank you, Madam Chair.
And then if you'll just make sure that we got your testimony, because I don't know that we have it with us right now. So
certainly we'll make sure we get that to you, Madam Chair. Good afternoon, committee. My name is Sarah Fertig. I am the Director of Government Relations for Blue Cross and Blue Shield of Kansas. We very much appreciate the opportunity to appear before you today. We are an opponent of House Bill 2593. Some of the earlier conferees have talked to you about some of the big picture concerns that some of the opponents have. Our testimony is going to get into the weeds a little bit, and hopefully we might be able to answer some of the questions that we've heard come out of the committee so far. So our concerns with the bill are really more technical in nature. And our two concerns are just generally, number one, that the bill itself is unclear. And number two, that the bill would insert confusion into an area where there currently is none without a good reason to do so. So first of all, talking about our concerns about the lack of clarity with the bill. So the bill would amend the current law to exclude only a contract of insurance from containing an arbitration clause that is binding on the parties. The term contract of insurance is not defined in the bill, however. We don't quite know what that means. And for an insurance company, we maintain tons of contracts. We have contracts with vendors, we have contracts with providers, we have contracts with employers, we have contracts with individual Kansans. It's not clear to us from the language of the bill what types of contracts this would specifically apply to. And I'll give you an example of where there's some real gray area here that the bill just does not clarify. And that's in the area of what's known as administrative services only, or ASO contracts. And that is where you have an employer that designs and funds its own health plan for its employees, and it hires an insurance company to administer the plan. So process claims, handle customer service, that type of thing. If any of you are a member of the state employee health plan, that is an excellent example of a government sector administrative services only contract. The state pays for those claims out of state coffers, and they hire companies like ours to process the claims and administer the plan. The question is, for an employer like that, is that a contract of insurance? They're not buying insurance from us. We are an insurance company. We're administering their insurance plan, but it's not clear from the text of the bill if that would be barred, if that would be part of the scope of the bill. So there's a lack of clarity in terms of what a contract of insurance means. And for a company the size and scope of ours, it's important that we know what areas would be potentially impacted. And it's just simply not clear based on the way the bill is drafted. It's also not clear to us, if this bill passed, how it would interact with other provisions of the Uniform Arbitration Act. So there's another section of the UAA that says the entire Uniform Arbitration Act applies to all arbitration agreements entered into on and after July 1, 2018. If this passed as is, would that serve to invalidate any potential arbitration agreement in a contract of insurance going all the way back 6 years to July of 2018? It's not clear. And for the lawyers in the room, there are statutory construction principles and legal interpretation principles that will not satisfactorily answer this question for you. I mean, yes, typically statutes operate prospectively unless there's legislative intent to have them operate retrospectively. We have a standalone statute saying all of these other statutes apply to any arbitration agreement on and after July 1, 2018. So would this serve to operate retrospectively? It's not clear to us. And again, this is confusion where there currently is none. We would also note, some of the other conferees noted that only insurance contracts would be carved out from acceptable arbitration clauses. And that's important to us because it's been indicated that all this bill is doing is clearing up a Scrivener's error from back when the bill passed in 2018. However, before 2018, the law actually carved out 3 exceptions to binding arbitration agreements. Contracts of insurance was one of them, but there were 2 more. One of them was contracts between an employer and employees or their respective representatives, or any provision of a contract providing for arbitration of a claim in court. So if what we're looking to do is reverse an oversight, why aren't all 3 of those things being added back into the bill? It's only contracts of insurance that are being added back in. So we do question that. And that would set the insurance industry apart from any other consumer contract out there. If there's an arbitration agreement in your cell phone contract, if you buy a refrigerator and there's something in your warranty, none of that is carved out, only contract of insurance. And again, we don't know what contract of insurance mean because it's not defined in this bill. So that's one of our large concerns about the bill, just the lack of clarity and what does this mean to our business? We would also note that this would really just insert confusion into an area where there is none already. It's come up repeatedly today that the Uniform Arbitration Act was passed in 2018. It passed with 0 opponents, 0 nay votes in the House or the Senate. The vote in the House was 122 to nothing. We had 3 absent legislators that day. The vote in the Senate was 40 to nothing. So overwhelming support. It was supported by the Bar Association and the Uniform Law Commission. And it has not been amended. Not a single statute in that entire act has been amended since it passed in 2018. We would question, if it's been working for 6 years, do we need to amend it now and inject confusion into it where there is none previously? So we would also note that there has been some concern raised in some of the questions about unfair arbitration contracts. If you look at line 10 of House Bill 2593, you'll note that the law already preserves the ability of a court to set aside an arbitration agreement on a ground that exists at law or equity. So you're talking about unconscionable contracts, contracts of adhesion, stuff like that. There already is a remedy in this bill itself for those types of unfair arbitration agreements that could arise over time. So again, we would question, what is the need for this type of bill injecting confusion into an area where there is none currently? So, Madam Chair, that concludes our testimony. I'm happy to stand for any questions the committee may have.
Okay, thank you so much for being here. Committee, do you have a question? Representative Carmichael and then Smith. Representative Smith and then Carmichael.
Thank you, Madam Chair. Thank you for your testimony. You made the statement that it's obviously been successful since 2018 and no amendments. How many times have cases been forced to arbitration in contradiction to what the insured wanted?
Madam Chair, I don't have the answer to that question.
How can we say it's been successful if we don't know the number of folks who have been forced into arbitration? It's been successful for you. Has it been successful for them? And I don't mean to put that in an argumentative way, but it's certainly something that we're trying to decide now whether it has been fair. So I think it's important when we talk about success, who it's been successful for. Thank you.
Madam Chair, my response to that would be that none of the statutes in the Arbitration Act have been amended in the 6 years since it was enacted, which indicates that things are going pretty well. There have also only been 2 court cases that have addressed anything related to arbitration at the appellate level in Kansas, at least that I was able to find. And they tended to hold in favor of the insured. So it does not seem to be an area where there's a lot of turbulence.
Representative Carmichael.
Thank you, Madam Chair. Ms. Furtick, I know you to be a lawyer of good reputation and good ability, but I want you to know you've really put us in a difficult circumstance here. You've raised a number of legal issues without the benefit of written testimony that would have allowed me to prepare to ask you meaningful questions here today. And I'm sorry that that happened, Madam Chair. Let me, though, turn to one point that you made in your presentation. And that has to do with whether or not this statute would, in essence, be retroactive, going back to the date of the enactment of the Uniform Arbitration Act. I think you correctly quote the law that statutes are prospective, meaning that they work forward, not retrospective, i.e. working back to 2018 if this bill were to pass, unless the legislature evidences an intent to make the statute retroactive. When I read this one-page long bill, I don't see any clause anywhere where it says that, and this act shall be retroactive to any particular date in the past. There's no mention whatsoever of retroactivity, is there?
Madam Chair, not on this particular page. Our concern is that there is a standalone statute in the Uniform Arbitration Act that makes the entire act applicable to arbitration agreements dated on and after July 1, 2018. And also, generally, a court can find that an act is intended to apply retrospectively if the statutory change is procedural or remedial in nature and does not prejudicially affect the party's substantive rights.
Well, I appreciate that, Madam Chair. We're not going to have time to argue prospective and retrospective, but this is a clear example of how the failure of the witness to bring us written testimony precludes us from adequately addressing an answer that has been an issue that's been raised for the first time with only 10 minutes left in the allotted time for the hearing. Thank you, Madam Chair.
Committee, do you have any other questions? Yes, Representative Titus.
Thank you, Madam Chair. You mentioned that the contract of insurance is unclear, but I think the intent of the proponents and the questions given here do make the intent relatively clear. What additional terms or definitions do you think would cover the issue?
Madam Chair, I would not want to do the work of the revisor for him. I think he would agree. I don't know how you could remedy this, Representative Titus. Our other concern remains, we would echo the concern of security benefit, that this is one subset of industry that is being carved out for particular treatment under the Arbitration Act, and we would question the wisdom of that.
Thank you. Madam Chair, I would just, if it would be appropriate, it would be good to hear from, I know we don't have time, but if the Bar Association might provide some written comments about why the other exceptions weren't included in the bill, I think that would be helpful context.
Yep, go ahead. Yeah, I mean, okay, committee, anything else? Okay, thank you. If you could get that, that would be great. And we appreciate you being here. Thank you. Okay, committee, I'm going to go ahead and close the hearing on House Bill 2593. And I'm going to open the hearing on House Bill 2660. And we will have our revisor give us an overview of that.
Thank you, Madam Chair, and good afternoon, committee. I'm not Natalie. Jason Thompson from the Office of Revisor of Statutes, filling in while she's at another meeting. Thankfully, I did write this bill, so you're in good hands, I hope. As the chair mentioned, House Bill 2660 is a bill regarding business entity filings with the Secretary of State, also dealing with registered office addresses by current occupants, and also information required in amendments to the Articles of Incorporation for a cooperative. And I note that this bill was requested by Mr. Barker on behalf of the Office of the Secretary of State, and he's here to give you testimony, so I'll try not to take up too much time. The bill brief is structured a little differently than the ones you normally get from us, and that's because the items are kind of grouped into a couple of big sections to hopefully help you digest them a little bit easier. New Section 1 is a standalone new section of law, so I'll highlight that briefly. This is the provision about a registered office of a covered entity. If that's a residential address, a new occupant of that residential address can have a process for letting the Secretary of State know that the registered agent is no longer at that address and it should be removed from the public record. And so that's what New Section 1 does. It provides a mechanism for a person who's in a residential address that was a registered office to have that removed from the record if it no longer is a registered office. Then there's a big chunk of sections that deal with just changes to the business entity report filing dates and issues related to business entity reports. And I won't go through each of those, but you'll see that's sections 2, 3, 5, 8, 9, 10, 13, 18, 19, 21, and 22. So all kinds of different entities that have their own statute, and it changes a date. It changes to a date certain, essentially April 15th or June 15th in one case, rather than a much longer series of words in each of those statutes. So it's more defined what the date is. Then there's another section of a group of sections where the requirement of certain entities to file a certificate of fact is removed. That's in section 11, 12, and 17. I believe the Secretary of State's representative can explain why that's removed in those three sections. Then section 5 and Section 6 are specific to cooperative reports. So there's a couple provisions related to just cooperatives, and there's a change to reference directors instead of trustees, and also just requiring their reports to contain the same information that's in other reports. And then there's a few other miscellaneous sort of provisions that we highlighted on the final page of the bill brief. And I'll just briefly hit those. Section 4 is one dealing with amendment of a cooperative's articles of incorporation. Section 7 is one dealing with revival of a corporation's articles of incorporation. Section 14 is one dealing with documentation that corporations are required to file with the Secretary of State to change the reference to a certificate of reinstatement, and it becomes a certificate of revival. That's the term we use now. And likewise, there's a reference about not-for-profit certificates of reinstatement. That's now also called a certificate of revival. So some language cleanup, essentially. Section 15 then deals with foreign covered entities and allows them to file a statement of good standing rather than a certificate of good standing. And then Section 16 deals with limited partnerships and their certificates, including a date upon which they were to dissolve. That's removed. It's no longer going to be required to be submitted. And then the last section, Section 20, is about partnerships becoming limited liability partnerships. And this would apparently make that provision more consistent with some other provisions governing limited partnerships. Hopefully, quickly got through all of those, and I'll answer any questions if I can.
Okay, thank you so much, Jason. Committee, do we have any questions for Jason? Okay, got off easy. Okay, we will have Clay Barker from the Secretary of State's office come up. Thank you for being so patient. We appreciate you being here.
Thank you, Madam Chair. I realize you've just had a lot of testimony on a contentious issue. I believe I'm the only conferee on this bill. And committee, thank you. Last year, you passed a very large corporate bill where we worked along with the Kansas Bar Association, had a lot of substance in it and a little bit of administrative filing on our part. And the reason this bill is being proposed is because our office has finally, after 5 years, finished replacing our antiquated 1980s computer system for business filings. We have a brand new system rolled out 3 weeks ago, and I should say this is Jameson Beckner, the head of our business services. And because you didn't hear about it, that means it's a success. We didn't fall flat on our face. It just worked. The reason this bill is here is we're trying to leverage aspects of that new computer system, and we look at two things: customer ideas or complaints, and the top reasons we tend to reject filings. If we can fix that internally with instructions, great. Sometimes we just want to change the law slightly, stay within the general legislative intent, make sure the public still has information. But if we can change small things to make the system work better, it saves money and time for everyone. And I'll briefly go down some of the highlights of the bill. You heard a lot of it is small things. First, there's essentially 12 different types of business entities, corporations, LLCs, and a lot of others. And we're just standardizing some of the things they have to file. We deleted references to obsolete things like certificates of fact, which are no longer issued, clarified words like reinstatement, revival, restoration, revocation, where they were misused once or twice because of the bill we passed last year. We didn't finish cleaning up. We got rid of some provisions that require us to charge a fee to customers. It's no longer necessary because the computer system does it automatically. So they shouldn't be charged money for that. There's no staff work involved. On the resident agent issue, I'll just give you the example that caused us to put this new provision in here. We may be the only state that's done this so far. Individual had a business from his home in Wichita. He moved to Hutchinson, but he didn't change his resident address, so it was still the address in Wichita. A new family moves in, husband, wife, 3 kids, and the old owner in Hutchinson starts shooting out racist propaganda. People got online to find this guy, and they found the old address in Wichita and started sending letters to that address, to the resident agent address, threatening to burn the house down. And the person called us up. We didn't actually have statutory authority to take his address off. In that one case, we decided we had to do it for his safety. But this bill would allow that. It happens about once a month. The resident homeowner says, hey, I'm getting all this mail, and I'm not the person that should be getting it. This protects them. It doesn't affect businesses, which should take care of themselves. It makes it easier for out-of-state companies to file and get started in Kansas by simplifying what they have to give us. And in business law, a foreign company just means non-Kansas. It could be Missouri, could be, I guess, Afghanistan. Actually, we don't recognize Afghanistan, but Missouri and another country, the same process, but it makes it easier for them to file and get started in Kansas. And probably the biggest change, and we had to put this in about 12 different places, which is why the bill looks paper-wise or page-wise a little long, is that up until 2004, entities would file this annual report. It's 1 page, 2 pages sometimes, and they would pay a franchise tax. So the date the report was filed was pegged to the fiscal year of the entity. So companies would file all through the year, depending on their fiscal year. That franchise tax was eliminated in 2004 for the Secretary of State, but we still kept that fiscal year in there. So while most companies, their calendar year is their fiscal year, some aren't. So we'd have these reports tripling in all year. It was hard to message if someone changed their fiscal year. So we'd like to change this so every entity, they're due at the same time period. And it's essentially, you get to the end of the calendar year and you turn in your report sometime between January and April 15, just like individual taxes. That makes it a lot easier for us to message. Company changes its fiscal year, it doesn't affect anything. And we do send out plenty of reminders to companies that these reports are due. And they're just 1 to 2 pages. You do them online, hit the fee, hit send, and it's done. There's no need for paper or mailing. It's a pretty simple process. But this just greatly simplifies it for our staff, which makes it easier for our customers. And with that, Madam Chair, I know it's been a long day for you all. I'll stand for questions.
Okay, thank you so much, Clay. Committee questions? I think you did a great job explaining it. Thank you. Thank you. We'll work on this at some point, and thanks for being here. And I will close the hearing on 2660. Committee, just a couple of things. We're not going to work any bills today. We possibly could work bills Tuesday, Wednesday, or Thursday. If for some reason, which I don't know what it might be, but if you're not going to be here on one of those days, you need to get a replacement or substitute appointed for you. And if you would please let me know, because I will try to adjust. And, if we have bills that we're working and we need your input, then I may try to work around that. So, okay. Anything else, committee, for the good of the committee?